Okay, court is in session and calls number 332150. Case is style of State of Texas versus Laura Ann Carter. Ms. Carter, is that your full name?
Yes, sir.
How you doing, Ms. Carter?
I'm doing good.
I'm doing fine. Thanks for asking, Ms. Carter. You're here with Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
You're fine.
Okay, now, Mr. Boudreaux, you stated that you sent in a letter of representation on this case. Is that
Yes,
correct? And our court coordinator looked and we could not find that letter. So, Ms. Carter, what we're going to do with your case is going to be reset to give him time to get the letter of representation into the court. And what we'll do, we'll give you just a standard 30-day reset. Now, you're waiving arraignment, is that correct? Yeah, okay. Okay, would you think you have any objections?
No objection, Your Honor.
Okay, thank you.
Judge,
Yes,
if, just for the court's information, we have sent Mr. Pat Canal a request already for pretrial diversion. Mrs. Carter
okay,
is as a lady in her early 60s. She's never before had any trouble with
Okay.
the Department of Public Safety or the DPS or anything like that. And we believe that because of her condition, she was sort of blinded when the truck ran into the side of her car. So we believe that it would be a proper case that Mr. Canal will probably grant pretrial diversion.
let me ask you this, so you've already sent the letter to
Yes,
Mr.
sir.
Canal?
We sent it about last Friday or so.
Okay, so let's do this here. Let's reset it about 60 days, give Mr. Canal an opportunity to review that letter, and then when we come back, we might know something, whether or not you've been accepted or rejected. And because it usually takes some time to, let me see, y'all have the pretrial diversion every other month, if I'm not mistaken. Let's see, I think July. Mr. Coleman, do you know when the last time y'all had that pretrial diversion, was it last month?
I do not know, Judge.
April. I think they're gonna have it June. Let's put it in August. Okay, we're gonna reset it in August because I think it's getting ready to come up. It's usually like the first Thursday.
So I'll put on the second Thursday.
Okay, so we're gonna put it on the second Thursday in August. So that may give you enough time for Mr. Canal to make his decision, and then we'll know at that time whether or not she's been accepted or into the program.
Yes, sir. And
Okay.
we'll resend another letter, Judge, but sometimes.
Yeah, but she's gonna have to sign this reset because right now, because your letter is not on file, you're not the attorney of record in the computer. And so she'll have to sign the reset.
Certain. So.
Okay, but get that letter of representation and just state, Mr. Coleman, you have any objections to this being reset 60 days?
Not at all, Your Honor.
Okay, Ms. Carter, you can stand on that 4X over there and you're gonna sign the reset. Once you sign the reset, once you get your reset, you'll be free to go and you have a blessed day. And Mr. Boudreaux, you're free to go as well and you have a blessed day.
Yes, sir. Thank you, Judge.
You're welcome. Okay. Okay, State, I basically wanted y'all to stand in on this particular matter that we just had with Ms. Carter.
Yes,
At
sir.
this time,
Yes,
we're
sir.
getting ready to do the arraignment, so it may take a little time.
So may we be excused until such time as the court needs us?
Yes, you may be excused.
Thanks, Judge.
Thank you, Judge.
You're welcome. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here. This morning, we have what is called an arraignment. You have been asked to come here for an arraignment. The arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. We do not handle felony cases. Now, your felony cases are your most serious type cases. For example, felonies are divided, in Texas, felonies are divided into 5 categories. The highest category of a felony is what we call what is called a capital murder. If you're convicted for capital murder, the range of punishment is either life or death. Below the capital murder is the next highest felony, which is a first-degree felony. First-degree felony, the range of punishment is 5 to 99 years to life in the state penitentiary, a fine up to $10,000. Below the first-degree felony is the second-degree felony. And the range of punishment for a second-degree felony is 2 to 20 years in the state penitentiary, a fine up to $10,000. Below the second-degree felony is a third-degree felony. The range of punishment for a third-degree felony is 2 to 10 years, a fine up to $10,000. And the lowest felony that we have is a state jail felony. And the range of punishment for a state jail felony is 6 months to 2 years in a state jail, a fine up to $10,000. Now, the case that you have in this court is classified as a misdemeanor case. Misdemeanors are divided into 3 categories. The highest misdemeanor is a Class A. Then the second highest is a Class B. And the lowest misdemeanor is a Class C. Class C misdemeanors are normally handled in the JP court or the justice court or the city court or municipal court. And for example, a Class C misdemeanor could be a traffic ticket. It could be not having a seatbelt on. It could be a sticker violation. Now, they're normally handled in the JP court or the city court. However, when those cases, when a person appealed the conviction from one of those courts, then it comes up to this court. And then we are able to handle a Class C misdemeanor. Now, as I said earlier, a Class C misdemeanor, you cannot go to jail. You only could be given a fine only. The next highest misdemeanor is a Class B misdemeanor. With a Class B misdemeanor, the range of punishment is 0 days to 180 days in the county jail, which is 6 months, and or a fine up to from $0 up to $2,000. And the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is 0 days to 365 days in the county jail, which is 1 year, and or a fine from $0 to $4,000 or anywhere in between. Now, your case is classified as a misdemeanor. It's either Class A, Class B, or Class C. As a defendant in a criminal case, you have rights. Now, the first right that I'll go over is your right to have an attorney. That paperwork that you have on the tablet, I will go over that paperwork with you. And the paperwork, the first document is titled Judge's Explanation of Rights to Defendant Without Attorney. And that talks about your right to have an attorney. And it reads, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Now, the prosecutor is the assistant district attorney that works for the DA's office. And a waiver is you're waiving or giving up your right to have an attorney. Now, and I'll read that again and say, you may not speak to the prosecutor or the assistant DA about your case unless you sign a written waiver of your right to have an attorney, or you giving up your right to have an attorney. The next paragraph states, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, in bold printed states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset my case to hire an attorney, then you'll put your initials on the first line to the left. If your choice is, or if you have already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you put your initials on the third line to the left. If you have already been appointed a court-appointed attorney in this case, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, you will sign on the line that's titled defendant, and you will date it today's date, May 31st of 2022, on the line that's titled date. Now, for those of you who will be waiving your right to an attorney and representing yourself, you would have to read and sign the second document. That second document I will go over with you is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 31st day of May of 2022 by the County Court at Law, number 2 of Jefferson County, Texas, of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line that's titled defendant, and you will place today's date, May 31st of 2022, on the line that is titled date. Now, as a defendant in a criminal case, you have other rights. One other right that you have is your right to have a trial by jury. Where this young lady is sitting in that area over there, we call that the jury box. And basically, 6 citizens from Jefferson County will be selected to sit on your trial. And after listening to all of the evidence, they will decide whether or not you are guilty or innocent. Now, you also have a right to waive or give up your right to have a trial by jury. And by doing so, you will not have a jury trial to decide whether or not you're guilty or innocent. Your case will come before the judge or the court in one of three ways. One way it could come before the court is by way of a trial. We call that a bench trial. It's a trial before the judge only. The judge will listen to the evidence and the judge will decide whether or not you're guilty or innocent. If you are found guilty, then the judge will also assess the punishment within the punishment range of your offense. Your case can also come before the court by way of a plea bargain. It can come before the court by what a plea bargain is. You and the state will have a conference and y'all will decide and see if you can negotiate a settlement on your case. If you have reached a settlement, we call that an agreed plea bargain. And then your case will come before the court for the court to decide whether or not the court will follow or not follow the plea bargain agreements. Follow is to go along with it or not go along with it. Now, if the court does not go along with your plea bargain agreement, you have a right to take it back or to withdraw your plea. So for example, let's say you and the state has worked out a plea bargain agreement and the state says 2 days in jail. And then it comes before the court and the judge said, well, I'm not going to follow that plea bargain agreement. Then you say, well, judge, I take my plea back. You have a right to withdraw or take your plea back if the court does not follow your plea bargain agreement. Now, if the judge does follow the plea bargain agreement, if you decide to appeal your case, in essence, you want to have a higher court to look at your case to see whether or not you've been wrongfully convicted or the court committed an error by convicting you, then you can appeal. Your judge has to give you permission to appeal your case to a higher court. That higher court is located right above us. That's why I'm pointing up. It's called the Ninth Court of Appeals. And they will decide whether or not the court committed an error, whether they'll decide whether to grant or deny your appeal. If they find that the court committed an error or wrongfully convicted you, they can grant your appeal. If they find that that did not happen, they can deny your appeal. Now, if they deny your appeal, you can appeal it to a higher court than them. That higher court is located in Austin, Texas. It's called the Texas Court of Criminal Appeals. It's the highest criminal court in the state of Texas. And you will be filing what is called a pro se petition for the discretionary review. I'll explain that to you. Pro se means you by yourself. You won't have a lawyer. You'll be pro se. You'll be filing it on your own. And you'll be asking the Texas Court of Criminal Appeals to review your case to see if your appeal should have been granted, see if you've been wrongfully convicted, or see if the court committed an error by convicting you. Now, they can either grant or deny your pro se petition. If they grant your pro se petition, then they can simply find you not guilty, case is over, or they can order this court to give you a whole new trial. Now, if they deny your pro se petition, then at that point, your conviction will stand. So as I stated earlier, that's one way where your case can come before the court is by way of an agreed plea bargain. The other way it can come before the court is by way of an unagreed plea bargain. What an unagreed plea bargain is that you and the state or you and your attorney and the state have not been able to reach an agreement to settle your case. And so you say, well, I want the judge to decide the punishment. That's unagreed. I want the judge to decide the punishment. So the case will come before the court. We call that an unagreed plea bargain. Okay. So you have a right to have a trial by jury. If you waive your right to have a trial by jury, your case can come before the court by way of an agreed plea bargain, by way of an unagreed plea bargain, or by way of a bench trial. Now, the other right that you have is a right to have witnesses to come and testify in your case. Now, witnesses sit in that chair over there, we call that the witness stand. Witnesses, they can testify for you or against you. You can ask them questions. We either call it direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court. And by doing so, you will not be calling any witnesses. However, that does not mean the state will not be calling witnesses. They will be calling witnesses in the case. Now, you also have a right against self-incrimination. And what that means is you have a right not to testify. I know sometimes we look at television and we hear the phrase taking the fifth. That's what it means. You have a Fifth Amendment right against self-incrimination. And that just simply means you have a right not to testify in your own case. The government cannot force you to testify in your own case. Now, you can waive, which means to give up that right against self-incrimination. By doing so, you're saying that I will be testifying. I'll be waiving my right. I'll be giving up my right not to testify so that I can testify. And if you do that, then you will be testifying in your case. You also have a right of discovery. Discovery means you have a right to see the evidence that the state has against you in your case. We call that discovery. Now, you have a right to have access to the documents, videos, witness statements, your statement, and objects, whatever the state has as evidence in your case, you have a right to have access to that. If they had DNA or whatever, you have a right to have access to that. Now, you can waive or give up your right to discovery, which means that you can say, well, I don't want to have access to that. You have a right to waive or give up your right to have discovery. Now, everyone that's here, you're here because you've been arrested and you're out on bond. And you're out on bond either on a PR bond, that's a personal recognizance bond, a cash bond, where you put up the cash, all of the cash for the bond, or a surety bond, where you put up a percentage of that bond and you have a bondsman who is on your bond. Okay. Now, every day that you spent in jail, that time can be used as credit towards your punishment. Okay. Now, for example, if the state is offering, let's say you spent 5 days in jail, and let's say the state is offering to settle your case through a plea bargain agreement, 5 days in jail. What that means is that you won't have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for time served. Now, if they're offering 7 days in jail and you serve 5, that means you have to do 2 days in jail because you'll be given credit for the 5 that you've already done. Now, every day that you spent in jail is also credited as $100 per day that will go toward your fine and your court costs. So, for example, if you spent 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500, that means you won't have to pay the $500 because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be what we call taxed and retired. It's already been paid. That's what that means. Now, if they giving you fine and court costs of $700 and you spend 5 days in jail, that just simply means that you would have to pay $200. Now, if you can't pay the $200 on the day that your case is disposed of, then we could put you on a payment plan, or you could pay it off in installments. But let's say, even if they put you on a payment plan, or you won't be able to pay it off because you don't have the income, no problem, because the law allows the court to convert your fine and court costs to community service. Now, every hour that you do of community service, you get $12.50 that will go toward your fine and court costs. So if you work 8 hours of community service, that's $100. Okay, so you work 8 hours a day, that's $100 for that day that you work, that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. It's for people who's been in trouble for the first time. And pretrial diversion, with that program, if you get into the program, your case will be dismissed. And if you complete the program, it will be wiped off. We call it expunged. It'll be expunged, which means to be wiped off, deleted, or erased from your criminal record. Now, in order to get into the program, as I said, you have to be a first-time offender. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you with writing the letter to get into the program. And if you get into the program, case is dismissed, you complete the program, you could get expunged, which means deleted, erased, or wiped off from your criminal record. If you are a veteran of any one of the branches of the United States military, Jefferson County DA's office has another program that is called Veterans Court. It is also part of the pretrial diversion program. With that program, you get into the program, you complete the program, your case is dismissed, and you can get it expunged, which means deleted or wiped off from your record. So you have pretrial diversion and you have the Veterans Court, where your case can get deleted or wiped off or expunged from your record if you get into that program and the case is dismissed. All right. Now, this court, County Court at Law number 2, has a program that is called the Community Safety Initiative. The Community Safety Initiative is a program that is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, raise our family, and go to church. And the way the program works is we have a partnership with agencies in the local area. For example, we have a partnership with Spindletop, the young people who are in that in the jury box, they with Spindletop. And basically, what Spindletop will do, Spindletop can give you a private interview. They can do an assessment, and they can develop a treatment plan, either outpatient or inpatient, to address your mental health needs. Now, when I speak about mental health, I'm not just talking about, you don't have to be insane or incompetent for Spindletop to address your mental health needs. You might have anxiety, depression, it could be post-traumatic stress, it can be bipolar, it could be paranoid schizophrenia, ADD, it could be a whole host of other mental health issues that they can help you with. The other thing is, if you have an issue with drugs or alcohol, Spindletop has a program that is called ATOL, and the Alcohol and Drug Abuse Council has a program that is called OZAR. Both of those programs are programs that's designed to allow you to be screened. They can develop an assessment, and then you can either be given outpatient or inpatient treatment for your drug and alcohol needs. If you are unemployed and do not have a job, or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. CICE is a job training and a job placement program in either the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of those areas that you select, they will assist you at getting a job in the field that you are trained in. If you have not graduated from high school, you do not have your high school diploma, and you would like to get your high school diploma, CICE also has a program where you can get your GED. Now, all of these programs that I have just mentioned are beneficial in several ways. One way it's beneficial is it's free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. And the other way that is beneficial is either one of these programs could be used as community service towards your punishment. So for example, let's say you are in the job training program, and every hour that you're in that program, 1 hour will go to our community service, and $12.50 will go towards your fine and court costs. Or if you're in the mental health program or the drug and alcohol program, one hour of counseling, then that will go to our community service, and $12.50 will go toward your fine and court costs. It's the same way if you're learning a job in CICE. 1 hour will go toward your finding 1 hour will go towards your community service, and the other, and then $12.50 will go toward your fine and court costs. So you're doing one thing, but you're getting credit for three things. One thing, you're getting credit for being in the program, you're getting credit for paying your fine and court costs, and you're getting credit for community service. You're doing one thing, but you're getting credit for three. All of those programs are available through our CSI program, the Community Safety Initiative. And the only thing I said earlier, you just have to have a desire to be in the program. And I tell people this all the time, when you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court, and we're trying to make a difference in Jefferson County, the county in which we live in. And I tell people this all the time as well, when you come to county court at law number 2, we do not just give time, we take our time, because we don't just arrest the problem, we address the problem. And we believe that by addressing the problem, we can produce productive people. If we produce productive people have too much to lose, and they will not be committing crimes, and therefore we'll make Jefferson County a safer place for all of us to live, work, go to school, and raise our children. Now, we have, as I mentioned to you earlier, that we have some young people here from Spindletop, and we're going to have one of them to come forward. We're going to have Deputy Hinton, who is our mental health officer. He's going to come forward, and he's going to tell you a little something about the program that they have at Spindletop. And at this time, Deputy Hinton, would you please come forward? You're welcome.
Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state of Texas. I'm here with my partner, Sarah. Sarah is a qualified mental health professional in Spindletop. The reason we're here today is because the judge has invited us into his courtroom because he cares about every single person that comes before him. What the judge has found, more so than not, people who appear with legal issues commonly have either mental health or substance use disorders. If this applies to you, the judge believes that he can help you with these underlying issues, he can get you out of the cycle of arrest. Now, maybe this is your first time to be here, maybe it's your 10th time to be here. There's still hope. We have a system in place where we can connect you to resources, options, services that can provide you what you particularly need for your particular situation. Whatever that may be, we don't know. So I'm going to ask you to do something that may be a little bit uncomfortable. I'm going to ask you to share that need with us this morning so that we can make you and help you connect to services that best fit your situation. Now, I also have to give you this flyer. On the back of it tells you a little bit about our court program, what we do here and why we're here. Also on the front has a 1-800 number. That number is a crisis hotline number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Our objective, our goal is to advocate for you to help get you out of the cycle of arrest if this is something that you believe is of value. Now, maybe this doesn't apply to you, maybe it applies to a family member or another friend, would still get this in your hands so that you can actually present this to them, and we can actually work through y'all to getting them the resources and getting them connected to get the help they need as well. There's also a document on your clipboard, which is a demographic. It's something required by the state for us to have our funding. It's information. Also, when you fill that out, there's a box on there that you would want us to call, text you later if you don't want to talk today. I get that. Sometimes it's uncomfortable talking in a setting like this. If you want to do that, if you'll just fill that out, check that box, sign it at the bottom, present it to us. It's all HIPAA regulated, which means your information will not be shared outside Sarah and I without your permission. So the information will be just to follow up with y'all and get you the information and the connection to resources that are best benefit y'all. Thank you all very much. Thank you, Your Honor.
All right, you're welcome. Ladies and gentlemen, the paperwork that you have on the clipboard, we're going to have someone with our court staff who is going to come by. And if you need some help with the paperwork, they'll be happy to help you with that paperwork. This is going to take a few minutes, so just be patient with us. And at this time, if you finish filling out the paperwork, if you need to use the restroom, something like that, you can, but make sure that you do not leave the courthouse, because if you leave the courthouse and we call your name, you're not here, your bond can be forfeited. If your bond is forfeited, you understand that that can result in an issuance of a warrant for your arrest. So if you need to use the restroom, you can, but please do not leave the courthouse. Just come back and have a seat in the courtroom. Now, the restrooms are right outside the door. It'll be to your right. Once you get outside the door, the men's restroom is the first one by County Code Law number 3, and the women's restroom is on the other side by, I think, the 136 Judicial District, or 172nd Judicial District Court. Okay, right across the hall. So at this time, we'll be in recess